Hi, I'm Olivia, a custody advisor with Wall Street Prison Consultants. Today, I'm going to explain bank fraud defenses and penalties. Bank fraud, defined under 18 U.S. Code Section 1344, is a federal crime and can ensnare individuals who didn't intend to do anything wrong. It is investigated by the FBI and U.S. Secret Service. To secure a conviction, the government must demonstrate that you knowingly committed or attempted fraud against a financial institution. This could even include mistakes on paperwork, making the prospect of federal charges, with the possibility of prison, asset forfeiture, or damage to your reputation, quite daunting. The key term is knowingly. Innocent oversights, such as forgetting an old debt on a loan application, or mistakenly using a nickname on an official form, might be construed as fraud. However, these might be mere inadvertent or careless errors. Defenses to bank fraud typically begin with a lack of intent to defraud. Since the law requires a knowing execution of a scheme to deceive, proving what was in someone's mind at the time of the alleged fraud can be challenging. Courts have widely interpreted this requirement, allowing prosecutors to prove intent to defraud an account holder at the bank rather than the bank itself. Legal defenses may also include the claim of a genuine mistake, such as forgetting a previous credit card or misjudging income. Distinguishing between a deliberate fraud attempt and an accidental error can be complex. People might fill out a bank form with good intentions, or submit an incomplete form inadvertently, only to be surprised by criminal charges. Such misunderstandings can lead to charges of bank fraud, even when there is no conscious wrongdoing. Avoiding liability can be achieved by clearly demonstrating no intent to defraud, whether an individual, an entity with a bank account, or the bank itself. An example would be securing a business loan with mistaken information. If it can be shown that this was a genuine mistake rather than intentional, liability could be avoided. Similar to a lack of intent, if you can show that you, in good faith, believed that your actions were legal and were for a legitimate business purpose, then you can avoid criminal liability for bank fraud. This can be somewhat difficult, as you'll have to establish the contours and expectations of your knowledge. In the event that your bank fraud charge is based on fraudulent misrepresentation, you can avoid liability by asserting that the misrepresented information at issue was not actually material information sufficiently relevant and significant to potentially influence the decisions made by the bank. For example, if you misrepresent your address information on your business loan proposal, that is likely to be considered immaterial for the purposes of a bank fraud charge. While prosecutors in bank fraud cases will likely have plenty of evidence at their disposal, not every case results in a conviction, due in large part to the availability of defenses in a bank fraud trial. Every case is different, and not every defense will be available in a specific bank fraud case. Duress can operate as an absolute defense to a fraud charge. If you intentionally committed bank fraud, but did so only because you were subjected to the threat of physical violence or some other coercive pressure, then you cannot be held criminally liable. Normal pressures are not sufficient to constitute duress. Typically, duress requires the imposition of unlawful pressure from a third-party individual or entity. For example, if someone threatens to harm your family unless you commit fraud on their behalf, that would qualify as a situation of duress. No matter what charge you are accused of, you have rights protected by the United States Constitution. If the police violate those rights while investigating you, their conduct could result in the dismissal of your case. Proving a case of fraud can take a large volume of your records. If law enforcement obtained your financial records, or other evidence in violation of the law, your legal counsel can move to suppress the use of that evidence at your trial. If successful, this suppression could result in the dismissal of your case. Lacking mental capacity. Mistake is not the only grounds under which a defendant could avoid a conviction for not understanding the consequences. If a defendant lacked the mental capacity at the time to understand that what they were doing was a crime, they could have a valid legal defense.